In summary, we've got Construction Act 1996, which is amended by Construction Act 2009. There are three principal areas which will affect your business. Firstly, adjudication. Secondly, suspension. And thirdly, payment. And what we're going to do for the rest of this seminar is examine in detail the changes under these three headings. So starting off with adjudication. This contains enormous changes, and we at Knowles do believe that this will have a major impact on the disputes that we are involved in. As far as I'm concerned, the first change we have is a huge change. Again, we have to go back to the initial piece of legislation, the Construction Act 1996, and look at what that particular piece of legislation said, and then review how it's going to be changed. Under the Construction Act 96, Section 107 clearly said that in order for the parties to a construction contract to take a dispute to adjudication, the contract had to be in writing. And whilst employers and main contractors were pretty good at sorting that out, and main contractors to subcontractors were also pretty good at sorting that out, there were certainly situations where the contract was not concluded. And the further down the supply chain you go, the less likely it is that actually there is a written contract. Anyway, the good news for those further down the chain, or for those that didn't manage to sort the construction contract out, or as someone said to me a few days ago, but we formed the contract on the basis of a verbal handshake, and I took a big gulp at that particular point. The good news here is that these construction contracts no longer need to be in writing or evidenced in writing. You can see there the little bit in italics against Section 1. It clearly says Section 107 is repealed. So in other words, if the parties have made a contract orally, or if they've made a contract in writing, they will be able to go and resolve their dispute in adjudication. Remembering the importance of this, if the parties had to take the matter to court, it could easily take 1, 2, 3 years to resolve it through the courts. By going to an adjudication, you will have a decision within 28 days from the referring party actually giving the full matter regarding their dispute and sending that to the adjudicator. 28 days is a significantly different period than the 1 to 2 years or even longer that you would be looking at on a litigation matter or on an arbitration matter. Unfortunately, the story doesn't end there on this particular section. And the main old chestnut that we come across at Knowles is this issue of letters of intent. Is a letter of intent a contract? Well, thinking about what you need for a contract needs to have certainty of terms, consideration and intention to create legal relations. And it's actually a very difficult thing to work out whether a contract does exist or it doesn't, particularly when you're relying on oral or verbal evidence. And letters of intent do have a tendency to complicate the matters. You'll see in red on the screen in front of you that it says it depends on the wording of the letter, which I realise does sound a little bit of a cop-out, but it's true. And indeed, even judges themselves can't reach agreement on this. A very recent case, RTS Flexible Systems and Muller in 2010. So for those of you who've had a yogurt this morning, perhaps it was on the production line that RTS themselves built. We start off here, the story, with a letter of intent. And alongside that letter of intent, there was an unsigned draft MF1 contract. And that unsigned draft MF1 contract included 17 unagreed schedules. And also, very importantly, this draft contract wasn't signed. And it also included a clause that said, this contract will not take effect until it's signed. So I'm sure everyone listening would agree that it doesn't sound like there was a contract in place, but we did have the letter of intent. The story then moves from a contract between RTS and Muller, the contract was worth 1.6 million, and a dispute of £500,000. This dispute then between RTS and Muller, RTS were not happy with the way they were being treated by Muller Yogurts, so off they went to the TCC. Now TCC stands for the Technology and Construction Court. There it was held that there was a contract between the parties, but it wasn't an MF1 contract, and unfortunately for RTS, the judge said, well, because the MF1 contract isn't applicable, there is no cap on liquidated damages. So in other words, RTS's liability for damages for late completion, obviously in this particular case it wasn't liquidated damages because there was no contract. Their damages were actually unliquidated. There was no cap on them. They were unlimited damages. RTS weren't happy with this answer, and so off they went to the Court of Appeal. The Court of Appeal looked at the evidence from RTS and Muller, and they also looked back at the TCC judgment. The Court of Appeal said, no, 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 TCC, you are wrong. In actual fact, there is no contract here after the letter of intent has expired. That in itself is a little bit strange, but hey-ho, the parties in this particular case, they had a letter of intent, and there was an expiry date in the letter of intent. So actually, there is a lot of sense to what the Court of Appeal held. And bearing in mind, the Court of Appeal simply said, well, the MF1 contract was unsigned, it was draft, and it clearly said it didn't come into play until the contract had been signed. I can understand exactly where the Court of Appeal were coming from. The story, however, doesn't end here either. RTS was still not happy with this particular judgment, and where did they go next? They went to the Supreme Court. Now, the Supreme Court is actually the new name for the House of Lords. They looked at the evidence provided by both parties, the TCC decision and the Court of Appeal decision, and they held that actually the TCC and the Court of Appeal were wrong. They decided that there was a contract, I'll just pause for effect here, and actually it was the unsigned draft contract which importantly for RTS included a cap on liability and included a cap on liquidated damages. I would even worry about estimating the likely costs on this particular case. Bearing in mind the original dispute was only £500,000, I have no doubt in suggesting that both parties spent significantly more than that, bearing in mind there were 3 separate sets of litigation and it went all the way to the House of Lords. The advice from Knowles is clear. Don't use letters of intent, and I actually think that, a bit like cigarettes, letters of intent should have a health warning on the bottom. Rather than seriously damaging your health, however, it should say that they can seriously damage your wealth, and this was definitely the case in relation to the RTS and Muller case. I have no doubt that there will be litigation on this issue going forward. What are the implications of the repeal of Section 107? So in other words, that contracts no longer need to be in writing for the parties going to adjudication. Well, I'm sure that arguments will shift to a, is there a contract or isn't there a contract? And unfortunately, you can't just simply follow the RTS and Muller case, because that case did turn on its own facts. There will be differences between your case and what actually happened in the RTS case. There will be increased costs for adjudications on oral contracts. No doubt adjudicators will be asking for more time because in many instances they will be being asked, well, first of all, make a decision on is there a contract, and then the contents of that contract, and then maybe you'll get to the actual dispute between the parties. Thicker submissions will be needed to prove the existence of a contract. There'll be more witness statements, who said what, when and to whom, and also an increase in hearings. On first blush, it is good news. So in summary, in relation to change number 1, the 2009 Act applies to oral contracts going forward. The key word there is contracts. There still needs to be a contract. Note that if your contract isn't compliant, with the provisions of the Construction Act 2009, then a document called the scheme will kick in. So in other words, if your contract is silent about a particular issue, the scheme will actually fill in the gaps in that particular situation. Our advice is clear. Agree the contract, sign it off, keep a copy, and only then start work. That's the best way that you can protect yourselves. The second issue, you'll be pleased to know, is a little bit easier to actually explain. And what we're talking about here is something called the slip rule. I'm sure you would find it hard to believe that adjudicators may make a mistake in their decision. Actually, it's a little bit more common than you think. If an adjudicator makes a clerical or typographical error, under the Construction Act 2009, they now have an express power to correct such an error. And this came around following the case of Law and Bomer. And quite simply, the adjudicator failed to take into account amounts previously paid by the main contractor. This was highlighted by the main contractor to the adjudicator after the adjudicator had issued his decision. And in fact, 3 hours after issuing his decision, he corrected the decision. As you can imagine, the subcontractor wasn't happy with the adjudicator correcting his decision, and he actually challenged it. The court agreed with the main contractor, who said, yes, you should have the power to correct clerical or typographical errors. And Section 140 of the Construction Act 2009 simply formalises that position. The third change that we're going to look at now under the heading of adjudication relates to adjudication costs. The Construction Act 1996 is currently silent on who pays the costs of the adjudication, unless both parties give the adjudicator jurisdiction during the adjudication to decide the costs. And there have certainly been attempts to include onerous provisions into the contract. You may have heard of tollent or tollant clauses. That followed the case of Bridgeway and Tollent. And the effect of a tollant clause is to basically make the referring party responsible for paying the adjudication costs of both parties and the adjudicator's fees on top. Indeed, in the case of Bridgeway and Tollent, they won in this particular action. From memory, it was around $40,000. But after they paid the other side's adjudication costs and their own costs and the adjudicator's costs, their win was reduced to a mere £8,000. The Construction Act 2009 now bans agreements allocating adjudication costs unless an agreement is made after the adjudication commences. This sounds very straightforward. However, there is a debate ongoing as to whether the amendment within the Construction Act 2009 actually means what it says. No doubt there will be some early case law on this matter. That concludes the first part of the presentation in relation to changes to adjudication, and we're now going to move on to the issue of payment.